Lords, immensely grateful for your patience this morning. I'm not going to test it, and I'm going to really take very, very briefly the...
No, not at all. I certainly hope we didn't give the impression that you were trying our patience. We're simply testing the argument.
Indeed, my Lord, indeed. And I didn't mean it in any other way, but I think the time has come to wrap up. And that's what I shall do. I just needed to give you a few references on the share transfers, and perhaps let's begin by looking at what I meant, my Lord Briggs, when I said that the shares, Sir Hamid's submission was that the shares were being held on trust.
Yeah.
I fear that may have been ambiguous. The submission wasn't that they were being held on trust for the other side, but that they were being held in Treasury. Let me show that to you. It's volume 2 at page 774. And this is in the course of the evidence of Sir Hamid's witness, of Mr. Venu Rao, for the funders. And you see an answer, the second answer on the page. As I said earlier, the process of share transfer forms is not relevant. That's a reference to the request for the shares to be transferred in August 2013. Because the company is taking the liability as per the agreement, the shares have to be surrendered to the company, means it has to be cancelled. And thus the fact mentions in other documents from your side and from my side, when you say surrendered, meaning it has to be cancelled, forfeited, nullified, so the shares do not exist. Whereas the share transfer forms came in a way that it has to be transferred to the promoters. And there's a further question, and I was drawing your attention to the intervention then by Sir Hamid. He's saying that the agreements was already surrendered, meaning it is not a transfer to the third party, will still be in his shoes for all the shares. It would be therefore surrendered to those parties which would be the companies that the company itself was making. The company can either keep it as a trustee of share or surrender whatever they want. And so he's saying that in the context of it has to go to the company, not to the other shareholders. And the concept of treasury shares, my lords, is under the Mauritian Companies Act. You find that at tab 19 of the authorities, page 2338. Section 71 and 72. So, cancellation of shares repurchase.
I'm so sorry, can you give me the page number again?
2338, my lord.
Thank you.
And you see 71, cancellation of shares repurchased, subject to section 72 to 74. Shares that are acquired by a company pursuant to section 69, 110, or redeemed are deemed to be cancelled immediately on acquisition. But we know from the parties' subsequent behavior that there's discussion in August 2013 about the transfer of those shares, so that doesn't seem to be what has happened. And what I think Sir Hamid was referring to, and what was the clear position we submit of the funders, bearing in mind what this witness is just saying, surrendered, forfeited, nullified, is the treasury shares under section 72. So this is why we say, my lord, that their clear position in the arbitration was that the shares were no longer theirs. Let's put it that way, then it avoids any ambiguity. Either for the company to hold in treasury, but certainly they were no longer their shares. And of course, my lord, that stands to reason, because their whole case was, we are no longer equity holders, we are now debt holders. We have given up those shares in order to have a debt. And I will show that to you briefly.
But I mean, assume that's the case, your complaint is that they've since been taking a position which conflicts with that.
Indeed, my lord.
But I mean, what's that got to do with us? I mean, that's a matter for you to take up in what appropriate proceedings. People think they are going back on something. But
that's relevant in two ways, my lord, to this appeal. First, that we say that the reason this has arisen is that the award is leaving it open to them to act inconsistently in that way. If the award had dealt with the issue of where we are in the implementation process, they could not be acting in that way. That goes to the annulment point, and that's because we say it's contrary, the award is thus contrary to public policy under section 39(2)(b)(2) of the Arbitration Act. It also goes, my lord, to our injunction, where we say that, and I'll come to that in a moment, but in a nutshell, we say that those parties are acting inconsistently in having told the arbitrator that they had surrendered their shares, and I quote again, forfeited, nullified, obtaining an award for $22 million plus very substantial running interest on the basis of that allegation, and then afterwards still going on to assert that they are shareholders in the company. We say that was a proper basis for the grant of the injunction.
Well, I don't think Sir Hamid was saying that the shares were to be taken as having been nullified. I think what he was responding, I think he intervened because it was being put to the witness, the witness being asked why there hadn't been share transfer forms completed, and the witness, the witness was trying to explain, and then Sir Hamid intervened to explain that what was envisaged wasn't a transfer to a third party, and therefore there was no need for a share transfer form. What was envisaged was that the shares would be, how did he put it?
Either keep it as trustee of share or surrender.
Yes, yes, exactly. Yeah. Yes, yes.
But, my lord, and that is my point, absolutely. The intervention comes to explain, I think, in the course of cross-examination, what the witness is saying, which is that it is really not the mechanism under the shareholders' agreement that there ought to be a transfer to the other promoters. And there's no dispute there. What I am saying is that what Sir Hamid did not say is, but of course these shares are still ours. He says the exact opposite. He says it's up to you, company, to see what you want to do with them. Cancel them or hold them in treasury, hold them in trust. He's certainly not saying they're still our shares. And he couldn't, my lord, because if you look...
Well, I'm not sure he actually... Well, we can see what he says.
Yeah.
On the page.
And if you look at page 781, that's the evidence of the witness. Is it your case that you have surrendered all your shares? Yes. This is your case? Yes. Couldn't be clearer, my lord. They were not taking the position that somehow those shares were still theirs in the sense that they could still exercise any rights as shareholders with respect to those shares. And if you look at, we've set out, if you just look at that briefly, it's more easily taken from our case at page 1785, 1786 of our case. And we've set out in paragraph 41 further passages of the funders. Our case, my lord, in the appeal at page 1785.
And
1786, 1785 to 1786. And it's the quotes at paragraph 41. What was the reason why you surrendered on 8th of October? And he explains, till that period of time, we were working with the company to see what steps the company is taking to raise money to pay the obligation. Since those efforts were not yielding any result at that point of time, we decided to hold back the number of shares. And in October, we surrendered the shares to convert it into other instruments. And then that was repeated under cross-examination. And finally, it was on that point I was going to show you their reply at page 694, reply of the funders, paragraphs 9C and 9D.
Sorry, the page, please.
694.
Thank you.
And you see here the basis on which it is put at 9C. While the amounts invested by the claimants under the earlier agreement was towards subscription of shares the respondent agreed to convert the same into debt and repay the same in tranches. And we say, well, that's correct. That's exactly what this agreement is. So they tell the arbitrator, our shares have been converted into debt. Their witness says to the arbitrator, we've surrendered all our shares. Their counsel, my learned father, tells the arbitrator, and it doesn't matter. It's up to them what they do with them, whether they cancel them or whether they hold them in treasury. All of this is entirely inconsistent with any remaining allegation that they could have both the debt and the shares. They have given up the shares in order to get the debt. They go to the arbitrator to enforce the debt. Once this is all gone and done, once they have the award in their back pocket, they go to the Indian courts and purport to exercise rights as equity shareholders.
Well, as you quoted paragraph 41, Mr. Rao's evidence that we surrender the shares to convert into other instruments. And that's what clause 5 envisages, that they will be surrendered and instead the former shareholders will be issued with convertible preference shares and the like. But that hasn't happened.
No, my lord, it hasn't happened, and that's exactly the mechanism. So the debt arises, the shares are surrendered, the debt arises, and you've got these other equity instruments, preference shares, which are there to secure that debt.
So their shares haven't been cancelled, they haven't been converted, the shareholders are presumably still registered shareholders, and they haven't been paid the debt owed to them either.
But, my lord, with respect, what they do, well, firstly, with respect to the preference shares, the one thing they do not do, which was entirely open for them to do in the arbitration, is there's a dispute about the debt, fine. They could also have said, and that debt is meant to be secured by certain instruments. Please issue those instruments. And that was the mechanism foreshadowed under the shareholders' agreement for them to then have leverage, to put it.
But as you explained earlier, those instruments were effectively security for payment of the debt.
Yes, my lord.
And there's no sign that the Vsoft are actually going to pay the debt or are in a position to pay the debt.
But, my lord, what they have also been asserting in the Indian proceedings is the same paragraphs, that they also concurrently hold those instruments because they also aver that they have 74% voting rights, right? And they now come to the board and accept that, of course, these instruments have not been issued to them. Because what ought to have happened under the shareholders' agreement, which they decide not to do, is that they should have asked the arbitrator, if that's what they wanted to do, also please ask them to issue those preference shares.
Was that within the scope of the arbitration?
My lord?
Was that within the scope of the arbitration?
Because they chose not to put it. What was in the scope of the arbitration were the claims that the parties were putting forward.
But it's your obligation. You can't really complain. It's all their fault because they didn't ask the arbitrator to make an order requiring us to comply with our obligation.
My lord, with respect, that's not my submission.
Right.
My submission is that the debt arises through conversion of the equity shareholding. And that, we respectfully submit, should be absolutely uncontroversial, is the position they themselves take. That deals with the equity shareholding, right? They could have asked, but they don't, for the preference shares to be issued. What I'm concerned with is, for the injunction, what is the position today? So far as the equity shareholding is concerned, we respectfully say it does not lie in their mouth to now say we can exercise rights under the 35% equity shares, having obtained an award on the express basis that these had been converted into debt. With respect to the preference shares, it's perfectly open to them, my lord, to take any step they wish to have these preference shares issued. Fine, they say we're in breach. They can act on that breach. What they can't do is run off to India and tell a court, short-circuiting any arbitration process, because of course the shareholders' agreement is subject to arbitration, and say act as if they had the voting rights, which they don't have. They're perfectly entitled to say, you're in breach, issue our preference shares, they stand converted, we will use our voting rights to force you to pay. That is what is contemplated under the shareholders' agreement. But what they can't do, again, I'm sorry, but for the equity shareholding, how can one say in the same breath to the arbitrator, this has been converted into debt, I'm owed $22 million, and once you have the award, then go to India and say, and I still hold those shares? That cannot be correct, my lord, as a matter of the inconsistency of their positions. And it's not an answer with respect to say, well, they may not have been cancelled, because there are, in fact, problems about cancelling shares like that, but let that be. Let's say factually they have not been cancelled in circumstances where in the arbitration they were saying it doesn't matter, it's up to the company what it does with that, which with respect was right.
Are these bearer shares, or are they registered as shareholders in the shareholders register?
My lords, I wouldn't be able to answer that question.
Well, I'd be surprised if they were bearer shares, but...
But what if... my lord,
just assume,
I'm
assume
thinking
they're
strongly.
not.
Say again.
It follows, if they haven't been cancelled, that probably their name is still recorded in the shareholders register as holding something like 33% of the shares. And they have they say, a contractual right, incidentally, to have them exchanged for money, preference shares, and a convertible share capable of giving them 51% of the voting rights in the event of default. And they haven't got the money, they haven't got the preference shares, and they haven't got the convertible share. So why is it so wrong for them to say, well, as far as we can see, we're still in the 30% position we started in because our name hasn't been taken off the shareholders register. And by the way, we're also entitled to have actually 51% control of this company because the other side are in default in their payment obligations.
My lord, the reason, and I'm focusing here on the injunction, the reason why it's quite wrong for them to say now that they still have rights to exercise any rights with respect to the equity shareholding is that they obtained the award on the express basis that they were no longer holders of that equity because that was the basis on which the debt arose. So, with respect, if one is using the shareholders agreement, then one has to follow what the shareholders agreement is providing for. It was providing that the equity shareholding would be replaced by a debt secured by other shareholding. For them to assert that they have that debt and that they're entitled to get that further preference shareholding, absolutely. But for them to, in the first place, obtain the award on the basis that their equity shareholding is no longer theirs because it's now a debt.
And just to intervene, you say that they did that on the basis of Mr. Sir Hamid's intervention during the witness's evidence.
No, my lord. We say they did that on the basis of their pleaded case at 9C and 9D, and of simply the way in which clauses 3 and 5 of their reply, and of the way in which clauses 3 and 5 of the shareholders' agreement operate. The whole scheme of the shareholders' agreement, which is accurately summarized in paragraph 9C of their reply, is that 1, they will surrender the shares, 2, those shares will be cancelled, and because of that cancellation, the debt arises. And the problem that is being debated, which Sir Hamid addresses, is, well, it doesn't look like they have been cancelled. And he could have said then, yes, they're not cancelled, they're still our shares. And you can imagine what the arbitrator's answer would have been. He would say, well, what are you saying? Are you saying that you're entitled to the shares, but also to the debt? He doesn't say that. Of course he doesn't say that. He says it's up to the company what they do. They can either hold them as treasury shares, or they can hold them, or they can cancel them. So if the actual factual position today were that they are the registered shareholders, in fact, there is a trust then, my lord, because the trust is, they are holding on trust for the company. They can't at the same time, my lord, benefit from the debt which has arisen from the conversion of the shareholding and from the shareholding. That's our basic position on the injunction.
Can you just help me? Where does the Supreme Court deal with the point you're now addressing? I mean, we're now dealing with the injunction.
Yeah.
We've got away from the award, and we're now dealing with the injunction.
It's at page 1052.
Yes.
of the judgment, my lord. And they deal with both injunctions together. As regard both claimants and Vsoft's injunction applications, in view of our decision to dismiss Vsoft's application, 2, the legitimate apprehensions which have been expressed by both parties in support of their applications. 3, the claimant's entitlement to proceed with the enforcement of the award, but which would be subject to the mechanism for the cancellation of the shares prescribed under the shareholders' agreement. We consider there are compelling reasons in the circumstances to make an order extending both interim injunctions until final enforcement of the award.
What's wrong with that?
My lord,
What's wrong with that?
no, my lord, but we do say that the injunction ought to be maintained. Is there?
I see.
I agree.
Suddenly gone.
That's-
I'm trying to understand where we got to. I mean, I thought we were dealing with your appeal against the award. We
My
now
lord,
seem to have
but
shifted
that's-
your response to the cross appeal.
Indeed, my lord.
I see.
Because that's simply because that point about the way they have been behaving in India
Yes.
is relevant both to the cross appeal, which we've just looked at, but I was making that point in support of our submission that the award is contrary to public policy, because it leaves the...
I just don't understand that aspect. I understand you're talking about the injunction,
Yeah.
but how it can be contrary to public policy for the arbitrator not to decide to allow doubled... your complaint is not that he decided something, but he didn't decide something.
Well, yeah, you've got a complaint. We say that he ought to have decided where
If
the
he had
parties...
decided, it would have been contrary to public policy.
My lord?
Never mind.
If he had decided it, there would be no issue of public policy, my lord, because he would have recorded in his award that the shares were no longer the funders to do what they wanted with.
Presumably it's the third point made, the point numbered 3, that's the relevant one for this.
Where are you, my lord? Sorry.
At 1052. Am I right? The concern is that the claimant's entitlement to enforce the award would be subject to the cancellation of the shares.
Yeah.
Well, that's true, but the award hasn't been enforced, and unless and until with any attempt to enforce it, what's the problem?
My lord, our injunction is on the basis that this party obtained relief, obtained an award of $22 million plus running interest on a basis which was that they were no longer the party entitled to exercise rights in relation to those shares, because that is how the debt arises, and that they are now taking the exact opposite position when it suits them and saying, well, we are entitled to exercise rights with respect to those shares.
Well,
it's as simple as
that. Are they going to get any money? I mean, if they attempt to enforce the award, are they going to obtain anything?
My lord, in terms of how, what the company can do, and if you wish, we can look at the Companies Act provision. There are two issues. If you're talking about...
I mean, I'm just wondering, I mean, you're effectively saying it's improper or at least inequitable for them to, as it were, have their cake and eat it. They can't both enforce the award and hang on to the shares. I'm just wondering if this is possibly academic.
But my lord, there's...
I mean, is there any prospect of the award being enforced?
I will answer that presently, my lord. First, I should simply remind your lordships that there is in fact a mechanism under the shareholders' agreement for them to take steps to enforce, and that's the preference shares. That's the first point. Secondly, obviously, I can't get into without prejudice considerations, etc., but there certainly have been discussions about how to honor this award. And to put it bluntly, it doesn't help a party that is trying to raise funding that its counterparty is going around India saying that they are fraudsters. If we're talking about the realities of the situation. Thirdly, there are company law provisions at play in that what happened is that these parties agreed, whereas they had a relationship inter se. There was an investment by Peepul and Millennium into Vsoft. There could have been an unwinding of that situation whereby Mr. Viraganta and Mr. Viswanathan would have agreed to discharge a debt. Instead, it is decided that it is the company that is going to take on the debt. That's fine, but that brings with it the Company Act provisions about meeting the solvency ratio. We're talking about large amounts, which is why you see both parties, when they are discussing in 2012, 2013, both parties, if you look at the letters, are saying, we're looking for funding. Because, put bluntly again, what is happening is that everyone realizes, unless we find replacement funding to put into this company is not going to be able to pay. So, yes, there is, and you've seen the correspondence. You can say whatever you want about it, and I have a few epithets that would come to mind, but it's certainly not someone who's trying to run away from the debt. And that has been the attitude. But in order to do that, funding needs to be found for the company.
And who's entitled to exercise the voting rights if it's not the respondents? I mean, we have these shares, they're not cancelled. There's a registered shareholder.
So I think I'm now, to be frank, I'm having to give you an answer on my feet, as it were, because we do not know what the exact position is. I think there are two possible answers. One is the one which Sir Hamid gave, which is that they are in effect being held in treasury, even though in the name of a registered shareholder. The other one, which is, and I did see you raise two eyebrows, my lord, but this is a situation where a party has obtained the benefit, or rather has ceded the benefit of the shares in order to obtain something else, which was the debt. And so whichever legal holder, whoever is the legal holder of the shares today, if it is the funders, then they're certainly not the beneficial holders thereof. The beneficial holders, because of the operation of the contract, would be the company. They obtain in return for it the debt.
But,
So,
I mean, it was never just going to be a personal obligation debt. It was always going to be a debt with security per Clause 5. Your clients haven't operated the security mechanism in Clause 5. And what is inequitable about, in those circumstances, the claimants saying, well, we haven't been given the security interest that we were supposed to get for the debt. We will continue to hold our shares as in lieu of that security interest until such time as we're given this security interest as the respondent should, the appellant should have provided us in the first place.
because, my lord, the being holders of equity is not simply having leverage, which is what being the holders of the preference shares is. Being holders of equity means that they can choose at any given point of time whether they'd rather act as debtors or whether they'd rather act as shareholders. And we say that is what is inequitable.
But forgive me, I thought that they'd made it clear that at such time as the debt is paid, they're very happy for the shares to be cancelled and for them to have no further interest.
But, my lord, why would they in the meantime be entitled to operate as if they were the equity shareholders? The correct solution, if they want to do anything, is to abide by what the parties have agreed. They themselves have invoked the shareholders' agreement, but they relied on it to obtain the award.
But it's your clients that have failed to operate the mechanism in Clause 5 to provide the security that they were supposed to provide.
Well, my lord, again, that was all subject to what was being submitted in the arbitration, which is that the default wasn't to be laid at the door of my clients. That was an issue in the arbitration, which we say wasn't decided. What they did not bring to the arbitration is to say, please, Mr. Arbitrator, rule on the validity of our debt and ask that these preference shares be issued. And with respect, my lord, it won't do to, one, invoke the contract when it suits them, and two, ignore it when it doesn't, because the preference shares will carry voting rights. Let's come back to the reality of the situation. They have voting rights in the company. What do they do with them in circumstances where the company is only going to be able to repay if it's solvent? They would then have to use those rights, certainly, but in a proactive way in order to obtain payment of the security in a way of their debt in a way which is compliant with company law. what I mean to say by that is it's not equivalent to say, well, it's all justice and conscionability. It's okay. It's true that they said they had given up on their equity shareholding, but because you haven't paid, let's pretend there isn't a whole agreement which said which rights they would be entitled to, and say, fine, pretend that you're equity shareholders. That is our complaint, my lord.
I think we have your point. That
Thank you, my lord.
the beneficial interest in the shares was surrendered in law, even if they didn't realise it, when they obtained an award of for payment of the debt instead.
Thank you, my lord. My lord, unless I can assist you further, these are my submissions.
And really, we've dealt with the cross-appeal as well as the appeal.
My lord, I believe so.
Yes.
I don't think you want to hear any further from me.
Right. Well, I think we'll take a few moments to consider where we've got to in this. Mr. Namda Khan, we don't require to hear you on the main appeal, but we would like to hear you on the cross appeal.
Yes, hello. What my learned friend, Mr. Moulin, submitted earlier was that the funders were taking inconsistent positions in the arbitration and in Indian proceedings. The fact of the matter is, as your lordships rightly pointed out, is that the contractual mechanism was there. We surrendered the shares on the 8th of October 2012. The shares were meant to be cancelled by Vsoft.
Okay, so can we just start by what are you now arguing for? You're attacking the injunction granted by the
Supreme Court.
Yes.
Preventing the claimants or funders to take any step directly or indirectly as shareholders of Vsoft. The shareholders' agreement under Clause 5, we have surrendered the shares. They had to be cancelled. They were not by Vsoft. And Vsoft had to issue the preference shares under Clause 5B and its subparagraphs of the agreement. So far, we have not been given the cumulative preference shares and the two other instruments in Clause 5B, C, and D of the agreement. The preference shares under Clause 5B, subparagraph A, would have given the funders the voting rights of 51%, as long as there is a payment default by Vsoft. That hasn't been issued. So the claimants are entitled to those instruments, and it is inequitable for them to have been subject to an injunction preventing them from doing anything directly or indirectly as shareholders of the company. The 35% shareholding, indeed it has been said by the claimants in Indian proceedings before the Registrar of Companies, the Hyderabad Court, District Court, the Hyderabad Supreme Court for the arbitration application injunction, that they are holding 35%. But the reason is not the arbitral award. The reason is that there's no evidence that the shares have ever been cancelled. So in those circumstances, the Indian proceedings were initiated by the funders because, in essence, their rights under the shareholders' agreement were not being respected. Several matters have been raised in those proceedings. The factual scenario is the same in each proceeding. What they are complaining about is, firstly, amendments to the Memorandum and Articles of Association of Vsoft Technologies Private Limited, the Indian company. They are complaining about private placement of shares to third parties. They are complaining about transactions with related parties, namely the company called Smart Staffing Resources, which is a company in which the father and wife of Mr. Viraganta are directors. They are also complaining about failure to receive financial statements from Vsoft. And all that is in breach of the shareholders' agreement. If I turn your Lordship's attention to Schedule 1 of that agreement, at page 451 of the brief. That schedule lists a number of reserved matters which cannot take place without the consent of Peepul and Millennium. Issuance of shares, merger or acquisition of or by the company or the company subsidiaries, listing of the equity shares of the company or the company subsidiaries on a recognized stock exchange, any sale of the business or assets of the company or the company subsidiaries, except in the ordinary course of business, including sale of investments in affiliates and subsidiaries. And my Lords, paragraph D is particularly relevant because this is exactly what has happened when Vsoft transferred the shares that it held in Vsoft Corporation, the US company, to another subsidiary of Vsoft, namely Vsoft India. So that has taken place without the consent of funders. Winding up or dissolution is not relevant. Buyback of shares not relevant. Declaration and payment of dividend. And H, amendment of memorandum and articles of association of the company or the company's subsidiaries. And that is what has happened in India with Vsoft India. On the next page, my Lords, page 452, there is also a list of reserved matters which cannot take place without the consent of funders. It is a more lengthier list than Schedule 1. And it includes at paragraph L, transactions with a related party. So what the funders have been doing in India is when they have seen things that were happening at the level of Vsoft Technologies Private Limited, which is a subsidiary of Vsoft, they have alerted the relevant authorities and gone to court to vindicate their rights.
But I mean, in a sense, to rely on these provisions, you don't need to assert that you're a shareholder. These are just contractual obligations.
Contractual obligations. But what they have said in the Indian proceedings is given the full factual picture to the authorities over there. So they have started with the investment agreement, the termination, the shareholders agreement, the arbitral award, and the statements about shareholding have been made in a broader context of trying to vindicate the rights under the shareholders agreement.
Sorry, I mean, the Supreme Court didn't really go into any of this, did they?
The Supreme Court did not go into
They seem to have just taken the
detail.
view that they should sort of preserve the position on both
Status
sides.
quo. Yeah.
Were these arguments made to them, or?
I don't believe they were made in submissions. There were affidavits exchanged in the proceedings, but in submissions, I don't believe that they were dealt with in great detail. Both injunctions, I believe they were dealt with in great detail.
But I have the impression that the injunctionists were seen as really standing or falling with the main issue about the award.
The claimant's injunction,
Yes.
which is the prevention of sale of the shares in Vsoft.
I understand that, but the way it's put by the Supreme Court on page 1052 looks as they regarded both the injunctions as sort of tarred with the same brush as really being ancillary to the main arguments, whereas you're saying there's actually quite separate considerations in relation to...
Yes, for us it's quite separate because we are prevented. We have the judgment, and there is no reason in our submission that the funders should be subject to an injunction preventing them from being
I mean, you say you were being stopped from doing something you were perfectly entitled to do.
Yes.
And can you help me, where is the order itself?
The Supreme Court order?
Yes, the injunction against your clients.
It is at page 1053 of the brief.
1053.
Yes. Granting Vsoft an interlocutory injunction, restraining and prohibiting the claimants from pursuing any action directly or indirectly on the basis that they are shareholders in Vsoft Holdings LLC, pending the enforcement of the arbitral award.
That's it, is it? There isn't an order in addition to the judgment?
Yes. Indirectly, the claimants are shareholders of Vsoft because they are entitled to the instruments under Clause 5B of the shareholders' agreement, the preference shares which would give them majority voting rights as long as Vsoft is in payment default.
Are they bearer shares? Are the equity shares, are the original shares bearer shares?
I'm not aware of that.
So the funders still appear as the registered owners of
They would have to be. They would have to be on the shareholders' register if the shares have not been cancelled. That would be the usual position.
Thank you.
My learned senior informs me that bearer shares are not allowed in Mauritius.
See.
So our submission is that there is really no reason for the claimants to be subject to such an injunction, which is drafted in particularly vague terms as well. We are not told what exactly the claimants are not allowed to do. If it was, as my learned friend Mr. Moulin said earlier, not to do anything to act as equity shareholders for the 35%, it might have made more sense, but a broad injunction like that is unwarranted in the circumstances. Those are my submissions, Your Lordships, unless I can be of...
Can I just make sure I've understood what this means? On page 1053, it says, restraining and prohibiting the claimants from pursuing any action directly or indirectly on the basis that they're shareholders. Does that mean legal action, i.e. proceedings in a court and giving evidence in a court, or does it mean taking any steps of any kind whatsoever?
That is what we are a bit at pains to understand from the...
Well, I'm assuming that might be illuminated by looking at the basis upon which the injunction was originally sought. Because if it was sought on the basis of an anti-suit injunction, that is, these people are going to courts all around the world making inconsistent claims, pursuing any action might mean legal proceedings.
Yes.
But if they're just saying these people are still claiming to be shareholders, then pursuing any action in pursuit of a claim on that basis might be interpreted rather more widely.
When Vsoft filed its first affidavit in the injunction case, in its injunction application, the facts that were relied upon were the Registrar of Companies complaint from June 2016 and the Hyderabad suit, which sought an order declaring that the shareholders' agreement was subsisting. So those were two proceedings at the time. In submissions, if I remember, it was agreed that essentially what Vsoft was asking for was an anti-suit injunction.
So do we have Vsoft's application?
Yes.
That was before the Supreme Court.
It would be at, as from page 1125 of the volume 4.
Which
Motion paper.
Which page?
1125.
Yes.
As from 1125.
But presumably there'll be some grounds somewhere or some evidence.
There will be an affidavit that follows the motion paper, starting on page 1128.
1128?
Be the affidavit.
Oh, I've got it, yes.
As from page 1134, Vsoft starts talking about the Registrar of Companies complaint.
But it's said to be on meritorious court actions and purported regulatory complaints at paragraph 4.
Yes.
Deals with proceedings in India, particularly the Hyderabad suit.
A further affidavit had been filed by Vsoft where they then talked about the arbitration injunction application as well. And in a further affidavit, Vsoft complained about a police complaint that the funders had made in Hyderabad.
Is there a response to this affidavit?
There have been responses. There were 2 or 3 affidavits before the funders filed a reply affidavit. So the first affidavit of the funders would be at page 1579.
I mean, none of this seems to have been gone into by the Supreme Court. I mean, this is sort of a slightly odd thing, that this is an originating application for an injunction in the Supreme Court with all this material, and it's simply not dealt with.
And it was one of the judges in the main case was the one who granted the interim injunction.
Yeah. But it seems to have been granted simply on the basis it was holding the ring pending something.
Pending. And in fact, the motion paper of Vsoft at page, going back to page
1125.
1126 at the bottom of the page.
And the application is made under Section 23 of the Act,
Yeah.
Yes.
which is to do with interim measures in relation to arbitration proceedings. And
The Supreme Court accepted jurisdiction, and it is perhaps the first case which has allowed that sort of interim injunction even after an award has been delivered. But if I turn your Lordship's attention to page 1126, at the bottom of the page, the application was made, as you say, to hold the ring. all the prayers sought are pending the determination of the application to set aside the award lodged by the applicant before the panel of 3 designated judges of the Supreme Court on the 26th and 27th of September 2016. There was a...
So just so I get the timing right, this is the original application at first instance?
Yes, on the 12th of September.
Right.
But the first instance is the Supreme Court.
Yes, of the Supreme Court.
A judge in chambers of the Supreme Court,
Right.
Yes.
who is a designated judge, but sitting alone.
Yeah, so I see.
And on my understanding, lost now my tab where we have that ruling, but there was a short ruling, and it was almost like a sort of American sign is hold the ring interlocutory
Yes,
injunction.
indeed.
Yeah, it's on page, I think it's on page 1551.
Or 1301?
Ah.
Oh, sorry, my lord might be right. I found my tab, which was page
Oh, yes, so
1301.
this is, I'm sorry, the one I'm looking at is an order for service, effectively. The 1301.
Yes.
1553 is the rule of the court, which it is the same order as 1551, but
Yeah, the one that I'd noted in the papers, but help me if I've got it wrong, is an order of the 12th of September 2016,
Yes.
page 1301.
1301.
That's what I've flagged.
It is the same document as 1553.
I'm so sorry.
Yes. Yes,
So-
one sees about two-thirds the way through it. But the status quo be maintained by both parties, and that respondents should abstain from pursuing any action, etc., pending the hearing, scheduled for later that month.
The hearings were postponed to January, and at the hearing of September, the order was enlarged until January.
So clearly that marries up with the originating application that you've shown us.
Yes.
But what was asked for from the Supreme Court on the appeal was something different. Plainly, they weren't going to
There it's pending.
extend, they were the hearing. So what was being asked for originally was just holding the ring until that hearing.
Yes.
So was there some new form of originating application on appeal?
No,
to the
there was no
court?
new application. That was the only injunction case brought by Vsoft before the Supreme Court.
But on that second occasion, they extended it not to pending the enforcement of the arbitral award.
I do not recollect that there was a motion made to extend the
No,
injunction.
but that's what they ordered.
That's what they ordered.
I'm just looking at 1053.
Yes. Whether Vsoft made a motion, and perhaps my learned friend can assist, I do not recollect a motion being made by Vsoft, even orally, when we were submitting in January, to ask for an enlargement of that order until enforcement of the award.
But bearing in mind they were upholding the award, which was a money judgment in your favour against them,
Yes.
it's slightly odd to find an injunction being granted,
Yes.
as it were, in the opposite direction.
Especially when the Supreme Court had rejected the public policy challenge on the ground of the claimants being given exit monies and shares in the company. That had been rejected by the Supreme Court. So it is odd that the judges enlarged that injunction pending enforcement of the award.
But were they asked to do so at the hearing? That's what I'm a little bit unclear about.
Do not think so. Honestly, I do not recollect that the motion was made in that sense, unless my learned friend appearing for Vsoft finds something otherwise in the court record.
Yes. And on page 1026, they sort of narrate the background. They say that there are, line 21, there are two more ancillary applications which have been made following the award. And then they number that, they tell us what they were. And the second one is the application made on the 12th of September 2016, which was the application under Section 23 of the Arbitration Act.
Yes. Well, both injunction applications were made under Section 23.
Yes, yes, yes. Well, the one that we're talking about. Which was an application pending this hearing. Yeah. So they seem to have thought that they could still exercise the jurisdiction under Section 23 to extend that injunction until the award had been implemented.
I suppose that is the reasoning of the judge. They do not say it clearly in the last paragraph of the judgment, but in the absence of a motion that such an enlargement be ordered.
Well, let's say it's on page 1052, line 39. We consider that there are compelling reasons to make an order extending both interim injunctions until the final enforcement of the award.
And that's the only reasoning that there is in the judgment.
Yeah. And so far as one can see the sort of the detail of the reasoning, it's because enforcement would involve the mechanism for cancellation of the shares. So that if you successfully enforce, your shares would be cancelled, and therefore you shouldn't be allowed to assert that you're a shareholder. I mean, I'm trying to reason it, I'm trying to expand out of that quite terse expression what the underlying thinking is.
The original 35% shareholding should be cancelled. Contractually,
Yes.
Vsoft should already have done that and issued the preference shares, and as long as they didn't pay.
But presumably if you got paid tranches 2 and 3 in full, what would happen? Would the preference shares be cancelled?
They would not be cancelled under the contract, but they would lose the 51% voting rights. So they would just
I'm putting that one on one, that's the convertible share.
the convertible share.
There seem to be two different groups of shares. There were the shares that, if you like, equate with tranches 2 and 3, which seem to be preference shares, and there's the convertible share which under Annex 4 can be turned into 51% voting rights on default.
The ones under paragraph C and D.
Yes, I'm sorry, I've numbered it wrong.
Yeah, 0.0001%, optionally redeemable cumulative preference share.
Is it that if the company pays tranche 2, that works as a redemption of that share? Is that how it works?
We would have to look at the constitution of Vsoft, the Mauritian company, but
Yes.
presumably it will be able to redeem those shares at its option.
And pray in aid, its payment of tranche 2 or 3, as the case may be, is the money for the redemption. Yeah.
Yes, well, thank you very much, Mr. Namdarkan. I think, Mr. Mullen, in fairness to you, we should give you an opportunity to comment on the question of the jurisdiction which the court was exercising when it granted the injunction.
Yes.
Whether this falls within the scope of Section 23, if that was the basis of the...
Yes, but I think the way both, it's important to understand, thank you, both injunctions are obtained in exactly the same way.
Yeah.
So what happened is first, the funders went to obtain an injunction ex parte under Section 23, which was effectively a freezing injunction. And then there were these developments in India, and we adopted the same method. And both are then treated in the same way. And if one is perfectly honest, I think, my lord, no one paid attention to the question of jurisdiction under Section 23, because that's simply how it arose, that's how it had to be dealt with. And of course, the Act provides for a clear mechanism. You have to go to a certain designated judge, It's then returnable before 3 judges, so it had to be done in that way. And everyone proceeded on the basis that at the hearing, there would be a determination by the court of whether effectively these would become permanent injunctions, and that is what happened. So I think the reality is one, if one falls because of that jurisdictional point, the other falls as well. But also, I think probably the better way of looking at things is that the court was exercising its general jurisdiction to grant injunctions, and we would ask you to analyze matters in this way, my lord. With your permission, my lords, I would respond in 3 minutes to a number of the points.
And I'm sorry, again, just thinking about it.
Yes?
What interest was the court protecting by the injunction? And the injunction is granted on the face of it, it looks as though it was intended to be in aid of the enforcement of the award, but it's granted against the party in whose favour the award was made.
No. The injunction was obtained, and my lords, it's correct that there are two possible bases. What was going on, broadly, it is an anti-suit injunction, but I say broadly because it's broader. It's not simply restraining the Hyderabad proceedings, etc. It's restraining actions which are being taken in India, which are broader than that, right? You know, police complaints, criminal complaints, etc., etc., letters being sent to regulators. So it is broader than an anti-suit injunction, and it was put on the basis that this was vexatious and oppressive, but also, and you find that from our skeleton, which is at volume 1, pages 164 to 169 is where this is covered.
And this is your skeleton for which of the hearings?
For the Supreme Court hearing, my lord.
The full one or the expired?
Yeah, the full one, my lord. And you see that it's put on two bases. One, it is, again, an anti-suit injunction, which could have been disconnected entirely from the question of shareholding or no shareholding. Because what is being said is that this is vexatious and oppressive in circumstances where the proceedings are going on in Mauritius. But if you look at paragraph 90, it's on the basis which I put to the board today, which is that it wasn't open to them to take the position that they were shareholders in circumstances where they had obtained the award on the basis that they were no longer shareholders.
Yes.
And as my Lord Sales was putting to my learned friend, many of the rights which he has referred to in Schedule 1, Schedule 2 of the shareholders' agreement are rights under the shareholders' agreement. They're rights which they enjoy as contracting parties. They are not restrained from exercising those if they wish to exercise them. And I would ask you to bear in mind that, and that applies to a lot of the submissions which my learned friend has made, these are all subject to an arbitration agreement. So if they wanted, for example, to exercise their rights under Schedule 1, which are rights under the shareholders' agreement, they have to do this by way of arbitration.
Well, if they want to go to court, but that presumably wouldn't stop them simply making assertions. That
No, they may make assertions that they are entitled to certain rights. But then the determination of those rights would be determinations of contractual rights. They don't turn on their being shareholders or not shareholders, as my Lord Sales was putting to my learned friend. And the determination would have to be under the arbitration agreement.
Can I just check for completeness? You wouldn't object to them asserting that they're entitled to receive the preference shares and the convertible share?
Well, my Lord, we have said that it's now common ground before you that these have not been issued. And we have said in our skeleton that if, for example, they wanted to start an arbitration to have that determined, they could. The injunction doesn't restrain that. The injunction restrains them saying that today they are shareholders. They're not. And that's all that the injunction is doing, my Lord. And with respect, in terms of the uncertainty of the wording of the injunction, my learned friend misreads, with due respect, what the injunction is doing. the word directly or indirectly is directed at the steps. The steps cannot be taken directly or indirectly. There's no question of being an indirect shareholder, whatever that's supposed to mean. They're not indirectly shareholders. Either they are or they are not. At the moment, they are not. If they want to pursue an action, if they want to assert in a legal action that they are shareholders and then obtain what they say is their due and get it, then they should do that.
If this is characterised as an application for an anti-suit injunction, did that not fall within the arbitration provision? So this is your client, seeking positive relief, as I understand it, in relation to the shareholder agreement. Did that not fall within the arbitration agreement?
By that point in time, there is no arbitration afoot. What we had is an award which makes certain determinations and which had been obtained on a certain basis.
Is there not an arbitration clause in the shareholder agreement?
There's an arbitration clause in the shareholders' agreement, but what Section 23 makes clear is that the court has concurrent jurisdiction with the arbitrator to go quickly or to summarize where the arbitrator is not able to act, which of course they are not because they have already delivered their award. Their functus officio. Now, I understand, my lord, that this is now raising questions as to, temporarily, how far could Section 23 go? But the same can be said of the injunction which my learned friends obtained, the freezing injunction, which was also obtained under Section 23.
But I mean, that seems more directly an injunction in support of the award. His clients have won, they've got an award for 22 million. They're fearful that there will be removal of assets by your client, and which would defeat the award, and they therefore seek a freezing order to protect the enforceability of the award.
Lord, our injunction does the same the other way, which it points out that the award is obtained on the basis that they are no longer shareholders. That was their position in the arbitration. Therefore, if you are enforcing this award, you cannot at the same time allow them to say that they are shareholders. That's the basis on which it was obtained.
This sounds very much, at the moment, to me, like a dispute or disagreement arising out of the agreement, out of the shareholder agreement.
Not the injunction, my lord. The injunction by the Supreme Court. Again, if one is going to say that Section 23 had either material limitations, i.e. what can you obtain under Section 23, or temporal limitations, till what date? Yes. This applies equally to both injunctions.
Yes, but you're not, as I understand it, you're no longer suggesting that the jurisdiction to grant this injunction arose under Section 23. You're relying on the court's general equitable jurisdiction to grant injunctions.
Yes, my lord.
Yeah.
Yes.
And so the question then may be whether the parties have, by contract, elected instead to have a matter of a dispute of this nature dealt with by arbitration.
Which would have been another reason to restrain the proceedings. Because, of course, we went under the vexatious and oppressive ground, but there's also jurisdiction to restrain the breach of an arbitration agreement. Yeah. So everything they were pursuing in India was in breach of the arbitration agreement.
Yes. I suppose you could say that that's a matter to be raised by people, if they're not happy with the court dealing with it.
Indeed. And I think I've heard my learned friend say quite fairly that really he didn't really have paraphrasing, but he didn't have an issue with the 35%, is what I'm hearing now, which with respect is very helpful. And you have our submissions on the preference shares. They are perfectly, nothing in the injunction prevents them from pursuing those rights if they wish to, but they must pursue them by way of arbitration. Yeah. Lord.
Thank you, Mr. Mullen. Is there anything new arising out of that, Mr. Ramdarkan?
No, I heard the points had been made before.
Yes.
Public policy challenges, so I responded to them.
I think we understand both parties' positions pretty well. Well, thank you both very much. The board will now take time to consider its judgment.